नमस्कार सर।
नमस्कार सर। फोन करूँ सर? टाइप कर देंगे।
ठंड का आतंक है। ठंड का आतंक है।
अरे सामने से कोई वो देखो कोई गोस्वामी पे हीटर वीटर पड़ा हो।
नहीं वैसे नहीं है, मतलब वैसे
नहीं लगवाना
नहीं ठीक है, वैसे ठीक है,
ब्लोअर वगैरह
वैसे ठीक है।
आज एक काम करिए, सुनो एक बार चेक कर ले, एक लगवाई दिख रहा है ब्लोअर, देखना ब्लोअर।
बिल्डिंग अंदर से तो गर्म लगती है, तो बाहर का माहौल बता रहा हूँ। बाहर
नहीं फ्रूट के लिए मैंने पहले बात की थी, ब्लोअर भी रखते हैं।
जी।
कुछ हुआ सर टेस्ट वेस्ट
अभी सर
Arya. Sir.
Namaskar. Welcome to the second session of Business Laws MMPC 13. In continuation of previous session in which we were exploring the Unit 3rd Partnership Act of 1932, let's revisit a portion that seems to be relatively relevant and interesting and important as well, which involves rights of partners unless otherwise agreed by the partners with certain rules. As I mentioned in the previous session, in contract, things are elaborately, mutually agreed upon, and these agreements, these conditions are subsequently followed during the course of any activity that is defined in that contract. Well, under normal cause, the partners have certain rights. For example, the one right, the first right, which is elaborated under Section 12A, right to participate in the conduct of business. Well, if it is not mentioned that one will not participate or what will be the level of participation, otherwise there is a right to participate in the conduct of the business. Well, next, right to be consulted. In case of any policy decision, any decision related to purchase, sale, any expansion, or any other activity which is related to business, the partners, all the partners have the right, equal rights to be consulted during the process of decision making. Well, right to access to the books. We all know every business involves maintenance of certain books like day book, cash book, other accounts book, and other books which are related to the maintenance or smooth running of any business activity. So every partner have equal right to access all those books, and it is well defined in the section 12D. Well, a right of legal heirs, representatives, their duly authorized agents, is also explained in the section 12E, right to share profits. It is inherent in contract between the partners that they have the right to share the profit. The level of profit or the percentage of profit in terms of sharing between among that may also be explained in the agreement or between the partners, depending upon their contribution and other conditions that are mutually agreed upon in the agreement. Well, interest on advances. In case of, which is elaborated on section 13D, well, in case there is some advance given by some partner or taken by some partner, so they are supposed to pay the interest on, and or they are supposed to get interest as well. It is very common understanding principle. Well, interest on capital, it is also defined in the section 13C. Well, right to be indemnified, it is also mentioned in the section 13E. Right to use partnership property under section 15. Well, under special circumstances, well, there may be circumstances which are not beyond expectation, beyond quite imagination. Everyone cannot imagine everything well before the start of any event. So in the event of any unforeseen incident or unforeseen activity, which is not defined in the partnership deed also, so under those special circumstances, there are certain rights. So like under section 21, various rights which are under special circumstances are under section 21, 31, and 32 and 33 respective subsections are also there. So under 21, under the case of emergency, a partner has power to act in an emergency for protecting the firm from loss. Considering a situation when there is a situation when a decision has to be taken in the one direction, left or right direction, and which without taking any decision. If in case of there is a situation, the decision is at abeyance or not taken, the firm will be at loss. So, and all the necessary formalities of consulting the other partners or taking them on board because they are not reachable or any other reason is relatively less feasible. So, under those circumstances, it is a situation of emergency. So, under this situation, a partner has a power to act in an emergency, especially where the consideration is he has to protect the interest of the firm from losses. He has to protect the firm from losses. Well, right to prevent admission of new partner under Section 31. Well, in case there are more than one partners, definitely a partner involves more. Definitely, minimum number of two is required in a partnership. So, in case there is another person who intend to join a partnership, by the consent of only one partner, so that is not allowed. So the all the partners have equal right that they may allow or they may deny the entry of new partner, and it is well defined under Section 31. Well, right to retire, uh, definitely it is not a bounding for a person to stay uh, uh, continuously in a partnership. He may retire or he may exit, or consider the option of exit out from the partnership. So the concept of retirement involves certain conditions, like he may retire with the consent of all the partners. So it is a mutual. There is definitely no dissent, no disagreement, no um, odd situation. One want to retire because he's not able to continue with the partnership due to health reason or any reason, or due to some other venturing into some other business. So well agreed upon that he will leave the partnership. Very good. So next is in accordance with an expressed agreement by partners. Suppose there is an expressed agreement between partners in the beginning or at a later stage that yeah, no, we will exit out from this partnership in this manner. Like suppose we attain this much of achievement, or we attain 1 year or 2 year of partnership, one will exit with certain conditions. So this may be done. Then there is another option in which a partner may give notice to their partners that he wish to exit. So this is called as notice at will, and it is defined under Section 31, subsection 1, section C. Whereas there is also a partner has a right to continue as partner. Definitely, it's a normal part right. Every partner has a right to continue in partnership and not to be expelled from firm by any majority of the partner. And it is defined under Section 33, subsection 1. So, like for a situation where there is a scenario, partners don't want to continue with one partner, and they by majority decide that you had to retire or you will be exit out forcefully. So he has the right, all the right to remain in the firm because he's a partner. So under this specific circumstances, still because the scenario is that a person or a partner is not doing in the interest of the firms, and other wish to remove him from the firm, and he is taking plea or taking advantage of rule under Section 33(1) that he cannot be expelled out, he wish to continue. So then there are other conditions also. Then there are other laws and bylaws which facilitates the certain situations. Then there are, like for example, um, there are rights of an outgoing partner to carry on competing business as well. That is under Section 36. So in addition to the previous rights under special circumstances, there are certain additional rights which are defined and well protected given in the Partnership Act. One is a partner may carry after he exit from the firm or from the partnership. So under 30 section 36, he may carry on a business competing with that of the firm, and he may advertise such a business, but subject to contract. To the contrary, he may not use the firm's name, definitely. So, represent himself as carrying on the business of the firm, definitely. Then solicit the custom of persons who were dealing with the firm before he ceased to be partner. So, here he can start the same business, same in the sense, same type of business in the same field, but he cannot use the same name of the previous firm. So that is the condition. He cannot claim himself to be the continuation of that firm because he has severed his ties with the previous firm. So this way, he has the right to continue, and there are other conditions also that we can explore in the subsequent sections of this particular course. During the exit from a contract, the partners may decide certain conditions. So, if he has been prohibited from continuing a business in the same field, that may also be considered. And if there is no such expressed condition, then it is well and good. But those conditions, whenever such conditions are imposed, those conditions should also be just. And we will be exploring the same situation in the subsequent sections and subsequent units in the same course, that how there is an understanding that these are the just conditions and these are unjust conditions imposed on a partner under force or any such condition. Those are not allowed. Well, in case of suppose one partner has left the contract, so still he has a right to share subsequent profits, and that is under section 37. And there are certain conditions. Well, suppose a partner has died, so it is a natural thing. So or otherwise ceased to be a partner, and the surviving or continuing partners carrying on the business of the firm with the property of the firm without any final settlement of accounts as between them and the outgoing partner or his estate. Then, in the absence of a contract to the contrary, the outgoing partner or his estate is entitled at the option of himself or his representative to such share of profits made since he ceased to be a partner as may be attributable to the use of his share of the property of the firm or to interest at the rate of 6% per annum on the amount of his share in the property of the firm. So definitely his rights are protected in terms of subsequent profits that firm earns. Well, we always talk about rights, but at the same time, it is important to understand and revisit the concept of duties as well. So partners do have some specific duties as well. So these duties are of two types, basically those envisaged in the partnership contract and those prescribed in the act. So as we explored in the terms of rights as well. So similarly, duties of the partners are also two types. One that are clearly mentioned in the partnership contract. So that can be well defined because that is well within the consideration of the partners that these can be our conditions. And we need to have certain duties during the ongoing activity in the business. But at the same time, there are some situations that may not be explained or expressed in the partnership contract, but they are considered as obvious one. So those are somehow described in the act as well. So partners may fix any duties, they may expressed or implied by a course of dealing, but these duties should not violate the act or the general principles of the contract. So definitely, as we mentioned, the point number B, that is those prescribed in the act, supersedes the agreement or contract that is written. So definitely anything cannot be done in contrary to the provisions or conditions or duties for the partners those are described in the Act. Well, as far as the duties that are described under the Act includes, Section 9 defines duty of the good faith or duty in the good faith. Well, definitely partners are bound to carry on the business of the firm to the greatest common advantage, to be just and faithful to each other, and to render true accounts and full information of all things affecting the firm to any partner or his legal representative. Duty to be just and faithful is a mutual duty on which the foundation of partnership stands. Well, duty to indemnify for loss caused by fraud, that it is defined in the Section 10. Every partner is bound to indemnify firm for any loss caused to it by his fraud in the conduct of business of the firm. Duty of due diligence, it is defined under Section 12B and 13A. Every partner is bound to attend diligently to the business of the firm, and in the absence of any agreement to the contrary, he is not entitled to receive any remuneration. Well, duty to proper use of property, it is under Section 15. Every partner must hold and use the partnership property exclusively for the purpose of firm's business only. Well, duty to account for profit and pay it to the firm under Section 16, subsection A. Well, definitely if a partner derives any profit for himself from any transaction of the firm or from the use of property or business connection of the firm or the firm name, he shall account for that profit and pay it to the firm only. Well, if a partner carries on any business of the same nature as the competing with that of firm, he shall account for and pay to the firm all profits made by him in that business. Well, duty not to compete, well, as it is mentioned under Section 16A, it is also expressed and explained under Section 16B as well. A partner must not compete with the firm without the consent of the other partners. Any profits made by such unauthorized competition can be claimed by the firm. So suppose a situation is that a partner is a member in two different firms, and those firms are competing in the same business. They are quoting their quotation from the same condition. So by virtue of his position in the partnership, he has the access to documents of those quotations that are submitted for competing bidding purposes. So one can fraudulently, under fraudulent intention, one can quote lower amount in a firm where he receives a better profit or more profit. So this kind of unauthorized competition is also not allowed. That is somehow expressed in the subsection 16B itself. Well, a partner who is guilty of willful neglect in the conduct of business and the firm suffers losses as a consequence is bound to make compensation to the firm and the other partners. It is expressed in the Section 13F. Well, no partners can assign or transfer his partnership interest to any other person. So as it is clear that the new partner cannot enter without the consent. Similarly, one cannot transfer his partnership to the others. This so as to make him as a partner in the business. So, but a partner may assign the profits and share in the partnership assets. But the assignee or transferee will have no right to ask for the accounts or to interfere in the management of the business. He would be entitled only to share the actual profits. On dissolution of the firm, he will be entitled to the share of the assets and also to accounts, but only from the date of dissolution, Section 29, where he can also be called as or considered as the partner of the partner, not as a partner, but he can be an extended partner to the partner. So every partner is bound to act within the scope of his actual authority only. If he exceeds his authority, he shall compensate the other partners for the loss unless they ratify his act. So here is a situation where a partner is assigned to act in a certain, suppose he is assigned to for purchases only, not for selling purpose. So in case he ventured into the selling as well, and the firm receives losses, so he has to compensate because he performed functions beyond his assigned role. Well, there is another situation where his this activity of selling a product of his firm beyond his assigned role is rectified or ratified by the other partners. They consider it considered his decision as a just and or a well expected or intended or that is the best possible action that can be taken. So in that case, if his action is ratified and firms still receive some losses, so he is not bound to be submit compensation for that. So these are the conditions. So then there is a next section in this unit, that is relation of partners to third parties. Well, there are two sets of relations. First, the relationship between the partners themselves, which we have explained, we have explored in detail, which are implied relations due to the rights and duties assigned arising out of contracted partnership. Well, second, relations of partner to third parties consists of business carried on by one or all members of the firm in the name of the firm. Well, they are responsible as a firm to their customers. Well, first, partners as agents. Well, they act on every partner, which is done to carry on in the usual way the business of the kind carried on by the firm, bind the firm and his partners, unless the partner so acting has no authority to act for the firm in that matter, and the person with whom he is dealing knows that he has no authority as well, does not know or believe him to be a partner. Well, authority of a partner. The authority of a partner means the capacity of a partner to bind the firm by his act. Well, this authority may be expressed or implied. Well, as far as the express authority is concerned, it is said to be expressed when it is given by words, spoken or written. The firm is bound by all acts of a partner done within the scope of his express authority, even if his acts are not within the scope of partnership business. Well, implied authority, which are expressed in section 19 and 22. Well, these are inferred from the conduct of parties, nature of business, circumstances, customs, and usage. They are considered or said to be implied authority. Well, implied authority is subject to following certain conditions. Well, the act done must relate to the normal business of the firm. The act must be done in the usual way or in the ordinary course of business. And the act must be done in name of firm. The general scope of implied authority is that it is limited to all that is just necessary to do the business and doesn't extend beyond that. Well, certain acts that are employed under implied authority are to sell firm's goods, to purchase goods for the firm, to accept any payment of debts due to the firm, and to engage and discharge employees. Well, in a trading firm, a partner has the following additional powers as well: to borrow money on the firm's credit and to pledge the firm's goods for that purpose, to accept, make, and issue negotiable instruments in the firm's name, and to employ a solicitor or attorney on behalf of the firm. It is, however, open to the partners by means of an express contract to extend or limit the implied authority. But third parties will be bound by such limitation only when they have notice of such curtailment. Well, all partners are liable jointly and severally for all acts or omissions binding on the firm, including liabilities arising from contracts as well, torts, when it is defined in Section 25. Well, this is also known as liability of partners for the acts of the firm, but in order that an act done may be an act of the firm and therefore binding on the firm as well, it is necessary that the partner doing the act on behalf of the firm must have done that act in the name of and on behalf of the firm and not in his personal capacity in any way. Well, that act must have been done in the ordinary course of the business of the firm. Well, it is defined in Section 19, subsection 1, as well as Section 22. Well, as we mentioned, as we explored somehow, there were two conditions. A partner cannot be entered, new partner cannot be entered without the consent, and one partner cannot be removed from the partnership or a contract by the majority decision. That is all given in the rights category under normal and special circumstances. Well, suppose there is a situation when there is a need to change the constitution of the firm. So it is called as somebody wants to join or somebody wants to retire, or there is a vacancy between on account of death or anything like that. So this situation or scenario where there is a upcoming change in the constitution of firm, it is called as reconstitution of the firm. Well, it may be due to on account of admission, death, retirement, expulsion. Well, if partnership carries on business other than the business for which it was originally formed, or when the partnership business is carried on the expiry of term fixed for the purpose. Well, there is also a consideration that usually partnership may be continuous or may continue in continuity as well. Well, if there is a partnership or an agreement which is designed or desired for a specific period, suppose two partners wish to continue a business for a specific occasion, for suppose a festival, Diwali festival or so. So, and they feel that suppose, for example, we can consider a homemade cookies business, and it was desired to continue or start this business only for the festival of New Year or so, and the partners feel that this business is well accepted among the clients and they can continue in a profitable manner. So and however, in their terms and condition, they decided to be specifically for a specific period of 1 month or 1 year or so. Well, on the expiry of that period, definitely they need to reconstitute it, the firm, and it involves certain provisions. So, in the event of admission to a new partner, no new partners can be introduced into the firm without the consent of all the existing partners. As a general rule, an incoming partner is not liable for the debt incurred before he joined the firm as a partner. Well, it is under Section 31(2). Well, incoming partner may, however, assume liability of the past debt by novation, that is, by tripartite agreement between the creditor of the firm, the partners existing at the time of death was incurred, and the incoming partner. Well, the scenario of retirement of partner, definitely we talk something about retirement. He can retire with the consent of all the other partners, no issue, no conflict, in accordance with expressed agreement among the partners. Suppose there is an agreement existing that one will exit or retire after 1 month, or attaining certain age. So that is well accepted, no confusion or controversy. This by giving written notice to all the partners of his intention to retire. If partnership is at will, outgoing partner remains liable for the partnership debts contracted while he was a partner. Well, he may, however, be discharged by novation, that is, by an agreement between himself, the new firm, and the creditor. Liable after retirement if he allows himself to be held out as a partner. Example, allowing his name to remain in the firm. To protect himself from his liability, he should give express notice of his retirement to the persons who were dealing with the firm before his retirement, or give public notice in the manner as laid down under Section 72 of the Act, That is to say, by publishing it in local official gazette and in at least one vernacular newspaper where the firm carries on business. It is defined under section 32, subsection 3. Well, expulsion of a partner. A partner can be expelled only if, we also consider this right. A partner cannot be expelled by majority, but when his actions are, when there are certain situations that the power of expulsion exists in a contract between the partners, and the power has been exercised by a majority of the partners. Well, it has been exercised in good faith as well. If all these conditions are not present, the expulsion is not deemed to be bona fide interest of the business of the firm. The right and liabilities of the expelled partners are same that of a retired partner. Well, death or insolvency, that is a normal, not natural process. The estate of a partner who dies or who becomes insolvent is not liable for partnership debts contracted after the date of the death or insolvency. It will, however, be liable for debts incurred before death or insolvency, and it is well written in the section 34 and 35. Well, in a situation when the firm has completed his work, or they wish to discontinue the work. So as far as the reconstitution is concerned, there is another concept that is called as dissolution. So dissolution under section 39, the dissolution of partnership between all the partners of a firm is called as dissolution of the firm. Well, the law of partnership makes a distinction between the dissolution of partnership and dissolution of firm. Where the relation between all the partners come to an end, it is the dissolution of the firm. I repeat again, where the relation between all the partners come to an end, it is dissolution of firm. Whereas there is a relation between some of the partners come to an end, then it is dissolution of partnership, not dissolution of firm. Well, there is an extinction of relationship between some of the partners only. So it is very much clear. As far as dissolution of partnership is concerned, it takes place even when there is no dissolution of the firm. As I mentioned earlier, on the expiry of fixed term for which the partnership was formed, it is defined in section 42A. On the completion of the adventure, suppose the event or activity is over under section 42B, the partnership will be over. On the death of a partner, section 42C. On the insolvency of partner, section 42D. And on the retirement of partner, 42E of the Partnership Act. Well, in all the above cases, the remaining partners may continue the firm in pursuance of an agreement to that effect. And if they do not continue, then the dissolution of the firm takes place automatically. Well, as far as the dissolution of the firm is concerned, it have certain, it is a graphical expression that is on the screen. Well, it may be by the order of court under section 44, and it may be without the order of court under section 40 to 43, like 48, 41, 42, 43. As far as it is without the court order, it may be by mutual agreement, compulsory dissolution under section 41, on happening of certain events under section 42, by notice under section 43. Well, by the order of court under section 44, insanity, misconduct, permanent incapacity, persistent breach of agreement, transfer of interest, continuous loss, just and equitable ground. Well, we quite clearly understand by mutual agreement a firm may be dissolved where all the partners agree. Well, by insolvency of all the partners but one, if all the partners or except one, all the partners become insolvent, the firm must come to an end. As a partnership firm with one partner cannot continue because the minimum condition is more than two, also more than one, means minimum number of two is required to be a partner. Well, by business becoming illegal. Suppose there is a change in law, there is a situation when a business which was previously active or allowed has been banned in the scenario. So, if such business, any firm is involved in such business, which has been defined as illegal, so subsequent events such as change in law, it is automatically or compulsorily dissolved by the operation of law. It is under section 41, subsection B. By notice of dissolution, where the partners is at will, the firm may be dissolved at any time by the partners giving notice in writing of his intention to dissolve the firm to all other partners. The dissolution will take place from the date mentioned in the notice or in no such date is if no such date is mentioned as from the date of the communication of the notice, and it is defined in section 43. Well, as far as the modes of dissolution of a firm is concerned, continuing with the graphics that we shared, by the order of court or by the without the order of the court. So agreement, by agreement, by compulsory dissolution under section 41, a firm is compulsory dissolved if adjudication of all the partners or of all the partners but one as insolvent, happening of any event which makes it unlawful for the business of the firm to be carried on or for the partners to carry it on in partnership, when more than one separate venture or undertaking is carried on by the firm, the illegality of one or more shall not of itself cause the dissolution of the firm in respect of its lawful adventures and undertaking. Well, dissolution of the happening of certain contingencies, section 42, subject to contract between the partners, a firm can be dissolved on the happening of any of the following, where firm is constituted for a fixed term or the expiry of that term, where the firm is constituted to carry out one or more adventures or undertaking them by completion thereof, by the death of a partner, and by the adjudication of a partner as an insolvent. Well, dissolution by notice of a partnership at will under section 43, where the partnership is at will, the firm may be dissolved by any partner giving notice in writing to all other partners in writing with his intention to dissolve the firm. The firm is dissolved as from the date of mentioned in the notice or the date of communication if the date of dissolution is not mentioned. Well, dissolution of a firm through a court order. Well, if a partner becomes of unsound mind, suppose there were two-person and or two members in a partnership, and one become a person of unsound mind, definitely it will be dissolved through the court. Permanent incapacity of a partner, well, misconduct of a partner affecting the business, well, persistent disregard of partnership agreement by the partner, well, transfer of interest or share by a partner, business working at loss, any just and equitable reason. Well, in a situation where there's a partner other than a partner suing willfully or persistently committing breaches of a partnership agreement relating to the management of the affairs of the firm or of the conduct of its business, or otherwise so conducts himself in a matter relating to the business that it is not reasonably practicable for the other partners to carry on the business in the partnership with him, the court may order dissolution at the instance of the other partners. Well, where the transfer of interest or share by a partner cannot assign his interest so as to introduce a new partner into the firm, where a partner has transferred the whole of his interest to a third person, or where his interest has been attached under the decree or sold under the process of law, the other partners may sue for dissolution. Well, business working at loss, if the court is satisfied that the business of the firm cannot be carried or expect at a loss, it may order for dissolution. Well, any just or equitable reason, as the grounds mentioned are not exhaustive, the court may dissolve a firm on any other ground. If it is satisfied that it would be just and equitable to dissolve the firm, the court may order dissolution where the substratum of the partnership firm has gone or where there is a complete deadlock and destruction of confidence between the partners. The or reference case is also there. Well, what can be the effect or what will be the effect of dissolution? Definitely, the partners make complete unfinished transactions, only the unfinished transaction, not no new assignment. But this authority is only for winding up of the affairs of the firm and not for a new transactions. Rights of partners on dissolution. Well, the partners have a right to business wound up after dissolution. It is defined in the section 46. Well, on dissolution, the firm, every partner or representative is entitled as against all the other partners or their representative to have the property of the firm applied in the payment of debts and liabilities of the firm and to have the surplus distributed among the partners or their representative according to their rights. Well, this lien can be enforced by injunction forbidding a fair distribution that is defined in section 46. The right to return of premium under section 51. So by entry into an existing firm, a new partner sometimes has to pay a premium to the existing partners in addition to any investment or capital. Well, on dissolution, he is entitled to demand the return of proportion of the premium if the partnership was for a fixed term and was dissolved before the expiry of that term, unless dissolution was caused by agreement or by misconduct of the party seeking return of the premium, death of the partner, that is under section 51. Rights where partnership contracts is rescinded for fraud or misrepresentation under section 52. Well, where contract creating partnership is rescinded on a ground of fraud or misrepresentation of any of the parties thereto, the party entitled to rescind is without prejudice to any other right entitled to a lien on the right or right of retention of the surplus of the assets of the firm remaining after the debt of the firm have been paid or for any sum paid by him for the purchase of a share in the firm and for any capital contributed by him. To rank as a creditor of the firm in respect of any payments made by him towards the debts of the firm and to be indemnified by the partner or partner guilty of fraud or misrepresentation against all the debts of the firm. Well, right to restrain from use of firm name or firm property under section 53. Well, after the firm is dissolved, every partner or his representative may in absence of a contract between the partners to the contrary restrain any other partner or his representative from carrying on a similar business in the firm name or from using any of the property of the firm for his own benefit until the affairs of the firm have been completely wound up, provided that where any partner or his representative has bought the goodwill of the firm, nothing in this section shall affect his right to use the firm name because someone has bought the goodwill, so that is the case as well. Partnership may, upon his anticipation of the dissolution of the firm, make an agreement that some or all of them will not carry on a business similar to that of the firm within a specified period or within specified local limits, and notwithstanding anything contained in section 27 of the Indian Contract Act 1872, such agreement shall be valid if the restrictions imposed are reasonable and not forced or unjust. Well, beyond this Partnership Act, there is an interesting act as well that it was formulated in the 2008. It is called as LLP Act or Limited Liability Partnership Act. Well, it was introduced on 12th of December 2008 and passed by both the Houses of Parliament and assented by the President on 7th Jan 2009 and called as Limited Liability Partnership Act 2008. It extends to whole of India. It fundamentally changes the nature of partnership from that of free and voluntary entity to a legal one. However, LLP Act does not harm the existence of Partnership Act. It remains as it is, and both are independent of each other. Well, LLP Act has 81 sections and 4 schedules. Well, first schedule deals with mutual rights and duties of partners as well as limited liabilities partnership and its partners, where there is an absence of a formal agreement with respect to them. Second schedule deals with conversion of a firm into LLP. Third schedule deals with conversion of a private company into LLP. The fourth schedule deals with the conversion of unlisted public company into LLP. So we understand that suppose someone want to start a new LLP, it's okay. Well, based on the benefits or advantages associated with the LLP, some existing firm wants to convert to LLP, there is a provision. Well, some private company want to switch to the LLP, that is a provision is there, and some unlisted public company wants to become LLP, so the schedules are there. Well, Ministry of Corporate Affairs and the Registrar of the company's ROC are entrusted with the task of administrating the LLP Act 2008. The central government has the authority to frame the rules with regard to LLP Act 2008 and can amend them by notification in the official gazette from time to time. Well, there are certain definitions of LLP, means a partnership formed by and registered under this act, that is under section 2N. Accordingly, LLP is a corporate body, for corporate form and incorporated under the act and is a legal entity separate from its that of its partner. LLP shall have a perpetual succession. Well, any change in the partners of a LLP shall not affect the existence, rights, and liabilities of the LLP. Well, in the previous slide, this slide, we can see clear difference, clear change or shift from the normal partnership form or normal firm to LLP. LLP giving more power to the firm. So it is a body corporate formed and incorporated into the act. It has got a separate legal entity, whereas in the partnership firm, it was not the case. All the partners were entitled for same legal entity separate from that of its partner. Therefore, LLP is liable to the full extent of its assets, but liability of the partners is limited to their agreed contribution only in the LLP. Creditors of LLP shall be the creditors of the LLP only. Perpetual succession. Any change in the partners of the LLP shall not affect the existence, rights, and liabilities of the LLP. That is defined in section 2(1) subsection D. Limited liability. The liability of the partners is limited to their agreed contribution in the LLP. Such contribution may be of tangible or intangible nature or both. Well, minimum and maximum number of partners, it is defined. At least 2 individuals are as a designated partners, of whom at least one shall be resident in the India. There is no maximum limit of partners in LLP. If in LLP all the partners are bodies, corporate, or in which one or more partners are individuals or bodies of corporate, at least 2 individuals who are partners of such LLP or nominees of such bodies, corporate, shall act as a designated partners. So there is an example. Well, LLP by the name of SMY LLP has 3 partners, namely SI Limited, MIS Limited, and YA Private Limited. So you can see all are corporate, not individuals. So this will not be considered for registration because the requirement of LLP is to have minimum 2 individual members as partners apart from the body. So accordingly, the said SMY LLP must consist of at least 5 partners, namely 3 body corporates and 2 individuals members. So to constitute the LLP, the 2 individuals need to be treated as a designated partner. Well, third party liabilities are unlimited to all partners. Well, it has got artificial status of artificial legal person. LLP is an artificial legal person because of it is created by legal process and is clothed with all the rights of an individual. LLP is invisible, intangible, immortal. It can be dissolved by law alone, but not fictitious because it really exists. Well, rights and duties. Mutual rights and duties of a partner within a LLP are governed by an agreement between the partners. In the absence of any such agreement, the mutual rights and duties shall be governed by the provision of the LLP Act 2008 as in the Partnership Act. Well, mutual agency. Every partner of LLP for the purpose of business of LLP is the agent of the LLP, but not of the other partners. It is defined as Section 26. In other words, no partner is liable on account of the independent or unauthorized actions of other partners. Thus, individual partners are shielded from joint liability created by partners, another partner's wrongful business decision or misconduct. For example, the professionals like engineering consultants, legal advisors, and accounting professionals are afraid of entering into business due to unlimited liability. Hence, the LLP Partnership Act provides an avenue for these professionals to limited liability partnership firms, which restricts their liability to the agreed amount. This has encouraged professionals to form LLP. Well, it is involved in the management of business. The partners in the LLP are entitled to manage the business of LLP, but only the designated partners are responsible for legal compliances. Well, business for profit only. The essential requirement for forming LLP is carrying on a lawful business with a view to earn profit. LLP cannot be formed for charitable and non-economic purposes. Well, it must have a common seal. Well, any LLP being an artificial person can act through its partners and designated partners. LLP may have a common seal if it decides to have one under Section 14, subsection C. Thus, it is not mandatory for a LLP to have a common seal. It shall remain under the custody of some responsible official, and it shall be affixed in the presence of at least two designated partners of the LLP. Well, as far as foreign LLPs are concerned, they can become a partner in the Indian LLP. It is defined in Section 21M, which defines foreign LLPs as a limited liability partnership formed, incorporated, or registered outside India, which is established as place of business within India. Well, who can be partner? A partner in relation to LLP means any person who become a partner in LLP in accordance with the LLP agreement. Well, Section 5 lays down that any individual or body corporate may be a partner in LLP, provided that an individual shall not be capable of becoming a partner if he has been found to be of unsound mind by court or competent jurisdiction, and the finding is in force. B, he is he's an undischarged insolvent, or he is applied to be adjudicated as an insolvent and his application is pending. Well, body corporate shall exclude a corporation sole, means a public official established by Act of Parliament, a sole office holder, a cooperative society, and any other body not being a company as defined as Section under Companies Act 2013. NBFCs are prohibited to be a partner of LLPs. Following can be partner: a company incorporated outside India. LLP can become a partner in another LLP. Well, a trust cannot become partner in LLP. However, trustee can be a partner in LLP in his individual capacity, but not in a representative capacity of the trust. Similarly, an HUF cannot become a partner but karta in his individual capacity, but not in representative capacity of HUF, that is karta. Well, liability of partners, the nature and extent of liability of a partner in LLP. Every partner of LLP would be, for the purpose of the business, an agent of the LLP, but not the other partners. Liability of the partner shall be limited except in case of unauthorized frauds and negligence, but a partner shall not be personally liable for the wrongful acts of or omission of the other partner. An obligation of the LLP, whether arising in contract or otherwise, solely the obligation of LLP. The liabilities of LLP shall be met out of the property of the LLP only. Well, a liability of a partner upon reduction of a minimum number of members in LLP. Well, if any event, any time, the number of partners of LLP is reduced below 2, the LLP carries on a business for the more than 6 months, while the number of so reduced, the person who is the only partner of the LLP during the time that is so carries on the business after those 6 months and has the knowledge of the fact that it is carrying on the business with him alone, shall be liable personally for the obligation of the LLP incurred during that period. Well, liability of the partner or holding out. The Act provides that any person not being the partner in the LLP who by words, spoken, written, or conduct represented himself or knowingly permits himself to be represented as a partner of LLP, known as a partner by holding out, is liable to any person who has on the faith of any such representative give credit to LLP. So it's somehow similar to the Partnership Act. Designated partners. So well, Section 7 defines a partner's appointment of at least two designated partners in mandatory for LLP. Well, they shall be accounted for regulatory and legal compliances beside their liability as a partner per se. Well, every LLP must have at least two individuals, um, and he must be a resident, means a person who stays in India in previous year not less than 182 days. Well, in a LLP where all the partners are bodies, corporates, or where one or more partners are individuals and bodies corporate, at least two individuals who are partner or such LLP or nominees of such bodies corporate shall act as a designated partner. Well, under Section 7, subsection 2, one become the designated partner if the incorporation document specifies such person or states that such each of the partner from time to time of LLP is to be designated partner. Then every partner shall be designated partner over the period of time in a sort of rotation. Well, any partner may become a designated partner or cease to be a designated partner in accordance with the LLP agreement. Well, an individual shall not become a designated partner unless he has given his prior consent. Every LLP shall file with ROC the particulars of every individual who has given his consent to act as designated partner within 30 days of his appointment. An individual eligible to be a designated partner must satisfy the condition and requirement as may be prescribed. Well, a person shall not be capable of being appointed as a designated partner of LLP if at any time within the preceding 5 years has been adjudicated as insolvent, suspended in time within the preceding 5 years, payment to his creditors, and has not at any time in the preceding 5 years made a composition with them, has been convicted for any offense involving moral turpitude and sentenced to imprisonment for not less than 6 months. Well, he has been convicted by court for any offense involving Section 30 of the LLP Act. Well, every designated partner must obtain designated partner identification number DPIN from the central government and provision of Section 153 to 59 of the Companies Act. If a person holds both DIN and DPIN, then DPIN shall stand cancelled and DIN shall be sufficient for being appointed as a designated partner. Every designated partner shall, in the event of any changes as stated in the Form 10 of DIR 3, intimate the central government in the form of DIR 6 under Companies Rule 2014. Well, the concerned designated partner shall fill in the relevant changes in the LLP on which he is designated partner within 13 days of such change. Well, there are certain liabilities of a designated partner. It is defined in Section 8. Well, they are responsible for performing all acts, matters, and things, including filing of all documents, return, a statement, and like report as mentioned in this act, and liable to all penalties imposed on the LLP for the contravention of those, the Partnership Act 1932 provisions. Well, change in the designated partners, well, it can be done within it has to be done within 30 days of the vacancy arising of any provisions. Well, then there are certain differences between the LLP and other forms of organization. So first explore the difference between LLP and partnership. LLP is regulated by their regulatory different acts. LLP is a corporate body, whereas partnership is not. LLP is a separate legal entity, whereas partnership is not. LLP is created by the legal process called registration under the LLP Act, whereas the partnership is created by the agreement between the partners. Registration is mandatory for LLP, whereas voluntary in partnership. LLP can sue or can be sued in whose name, whereas registered partnership firm can sue by third parties. Well, LLP has perpetual succession. The death, insanity, retirement, or insolvency of the partner does not affect its existence, whereas it changes the partnership. Well, differences between the name of the LLP to contain the word LLP, no such for the partnership. Well, liability of each partner limited to the extent. Well, similarly, there are a huge number of differences between the LLP and partnership. As far as the LLP company is concerned, they are regulated by different acts. The person who contribute to LLP are known as partners of the LLP. The person who invests in the money of the shares are known as shareholder members of the company. The internal governance structure of the LLP is governed by Contract between the partners. The internal governance structure of the company is regulated by the statutes of the company. Well, name of the LLP is contain LLP in it as a suffix. Well, name of the company, public company to contain the word limited, and private company to contain the word private limited as a suffix. Well, minimum 2 members and maximum no limits in the LLP Act. The members of the LLP can be individual, or the two-member condition is there. Well, liability of a partner is limited to extent of the agreed contribution, except in case of intention is fraud. Liability of a member is limited to the amount unpaid to the shares held by them. The business of LLP is managed by the partners, including the designated partners authorized in the agreement. The affairs of companies are managed by board of directors elected by the shareholders. Minimum 2 designated partners of LLP. Well, there are certain advantages and disadvantages associated with the LLP. So we will be exploring in that coming in the upcoming session. So with this, namaskar.